Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, hear. All persons having business with the Appellate Division are here. Give your attendance and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division First Department. We have oral arguments for today, September 24th. We have approximately 6 hours of argument time requested. So I'm going to ask that you please ask for the time that you need to get out the salient points of your arguments. Please keep in mind that we have read your briefs. We are fully familiar with your arguments. Please also know that the light is basically for you and not for us, in that if there are additional questions, which we have, we will certainly ask them. People v. Brian Gutierrez. That matter is submitted. 600 Associates versus Illinois Union Insurance. Yes, you're the appellant? I'm sorry? Appellant. Okay, so there's no respondent. Okay, 3 minutes. Matter of Luen. That matter is submitted. Wodsworth Associates versus New York State Division of Housing.
Appellant 5 and 2.
Respondent, DHCR 5 and 2.
You have a cross appeal?
Yes.
5 and 2, 5 and 2. Doe v. Archdiocese of New York.
Appellant 5 and 2. Respondent 5.
525. People v. Nicole Fields. That matter is submitted. People v. Shaquille Dinkens. 525. Uno A Brokerage versus Insure. 525. People v. Danielle Newell. 414. Gonzalez v. the City of New York is submitted. Gu v. G. 525. People v. Lamar Whitthall. 525. People v. Joseph Brown. That matter is submitted. Best Work Holdings v. Ma. That matter is submitted. I'm sorry. Oh, hi, how are you? You're a bit late, but that's okay. Who are you, appellant or respondent? And how much time are you requesting? And there's no appellant, so did you still wish to argue? Okay, 3 minutes. Thank you so much. People v. Vadim Schulman. 424. People v. Willie Santos. That matter is submitted. People v. Javier Rosario. That matter is submitted. Molnar v. Molnar is submitted. Cone v. RTW Retail Wins Acquisition is submitted. The first case for argument is 600 Associates versus Illinois Union Insurance. Oh, she said okay. Yes, please proceed.
Good afternoon, Your Honors. Please, may it please the court. I represent Appellant, Illinois Union Insurance Company. This case is an appeal of a denial of a summary judgment motion before the Bronx Supreme Court on an additional insured issue whereby the respondents seek additional insured coverage under my client's policy.
So Supreme Court denied the motion for summary judgment. So what is your position as to why this was error?
It was error because the additional insured endorsement in my client's policy has language that requires direct contractual privity with my client's policyholder. The respondents are not in direct contractual privity with my client's policyholder.
So it wouldn't matter that the policyholder was doing work at the site of the property owner, and that the party with which your policyholder contracted was to indemnify the property owner in the event that there was an issue?
It does not matter. My client is the insurance company. They are bound only by the policy that they wrote to our policyholder. They only provide additional insured coverage to entities that are in direct contractual privity with the policyholder. The respondents do not dispute that they are not. They also do not dispute that the contract that our policyholder entered into does not require additional insured coverage for the owner and the GC. The policyholder's contractual indemnification obligations are completely separate from the insurance company's obligations under the insurance policy. And I will note that it was also error for the trial court to deny the motion to renew and re-argue, because after the summary judgment motion was denied, the trial court subsequently dismissed the contractual claims against our policyholder brought by the respondent. So there are no contractual obligations either.
Didn't your policy say that it would cover owner?
Our policy does not say it will cover owner. It said it would cover the entities that our policyholder, and it covered the entities that our policyholder agreed to name in a written contract if our policyholder entered into that written contract with the additional insured. And so our policyholder is Lamar. They entered into a contract with an entity called Allen Boulevard Interiors. The contract between Allen Boulevard Interiors and Lamar defined Allen Boulevard Interiors, which is a non-party to this case, as owner/GC. So it was a defined term in the contract. And in fact, Illinois Union is defending Allen Boulevard. They are not seeking anything under the policy. It's 600 associates, entities, and mega contracting that are the entities that filed the case against Illinois Union that are seeking additional insured coverage. They're not entitled to it because they are not in privity with Lamar, and because Lamar did not agree in its contract with Allen Boulevard to name them as additional insureds.
Thank you. Thank you very much.
Thank you very much.
Wadsworth Associates versus New York State Division of Housing.
May it please the court, Arun Parambasekar for counsel for Wodsworth LLC, the appellant for the appeal and in opposition to the cross appeal. This is a DHCR, this is an appeal of a DHCR decision, so the issue is whether or not they engage in arbitrary and capricious conduct. Here, the main issue that we have is that they disclaimed labor costs for a contractor based on identity of interest. Our position is that is arbitrary and capricious because we provided proof of payment, bank statements, and affidavits. In the record below, they inquired about the contractor and they asked for subcontractor information. They made 2 requests for subcontractor information. Our position is that wasn't required on the rubric of what the DHCR's policy statement at the time, because this renovation happened in March of 2016. There was a subsequent policy that was developed afterwards that had a higher requirement, but the prior policy statement 90-10 specifically says, you know, you have to meet one of these 4 criteria of documents. If there's identity of interest, then they can ask more questions about proof of payment. The case law that I cite to goes to the DHCR's own precedent. So our basic position is that they should follow that. Matter of Shara provides context, and it says the agency in the context of these identity of interest issues is not supposed to assume malfeasance. And here, the DHCR cited to a case, and I think this is an Appellate Division First Department case, a matter of 1234 Broadway LLC. In that particular case, there was an identity of interest issue raised. The owner could not provide any proof of payment, provided affidavits, provided all sorts of other documentation. Here, we did provide proof of payment from the from the landlord, to the contractor. That, in and of itself, should be sufficient. Even, we did dispute whether or not an identity of interest issue existed, but even if I assume that is the case, and they can do this additional expansive review, we still fall into the requirements that they have. I also cite to another, they also cite to another case, matter of 7 West 87th. There, an affidavit wasn't good enough. There was no proof of payment.
So I'm sorry, I want to get back to because you seem to be conflating two issues. The first issue is why was the determination arbitrary and capricious as to the rent overcharges?
It was arbitrary and capricious because they disclaimed $86,000 worth of labor based on the claim that there was an identity of interest and that we didn't meet the requirements of additional documentary proof that would be required. And our position is that we did deal with that issue.
So your position is that there was no identity of interest between the parties?
We argue that, but I'm also saying that even if, so this was remanded.
Well, let's just stay with that point for the first issue. Was there, your argument is that there was no identity of interest, right? Is that correct?
Right, we made the
Based upon what?
based upon different bank accounts, different corporations. There was a complicated history with, there's two different entities. It so happened that one of the entities acquired the contractor years later.
So, but DHCR, they stated that your evidence was insufficient in terms of payroll records, I think in terms of payments made to the contractor, checks which were written, normal maintenance versus improvements. So you're stating that that was incorrect?
I am saying, Your Honor brought up a lot of points. I am saying that they are incorrect, and the main issue that was the identity of interest that's the main issue that they raised.
I'd like to follow up on that if I may.
Sure.
Let's assume that there was an identity of interest
Right.
issue, and I have two questions.
Right.
Now, did your client, submit? Well, let me say it this way, because there were paychecks that were submitted, employee paychecks, and my question is, because I didn't see it on there, did those paychecks set forth the apartment number or the address where the work was to be performed? Because that was one of the issues.
Right, so they didn't.
They did not.
They did not, but our position is that that was the contractor employees, not a direct employee of the landlord. The requirements, for example, if a super does the renovation, then in that context, yes, you're supposed to differentiate. I would just, because I know my time is up, I cited to a case that the DHCR has in Kings County, Levy versus New York State DHCR. It has almost the exact same fact pattern, but they go the other way. DHCR has defended that decision, and in that particular case, they did not require the payroll records.
So, but that was my question to you. I was stating that in addition to the lack of payroll records, the lack of any specificity on the checks that were written to the contractor in terms of what the work was to entail, the area, which apartments the work was to be done, and also the issue as to whether it was normal maintenance versus some substantial maintenance. So that differs from the other decision that you made reference to, does it not?
So what I'm saying is the paychecks from the employees of the subcontractor don't have any identification on that. That is true, but in this context, it is similar because in that case, there was itemized invoices and checks that weren't contemporaneous and that did not reference the apartment.
Right, but that in that particular case, that was one of the sole issues or one of the sole factors. Here we have other factors, which I just
I would say that the identity of interest was also raised in that case, and that's where that whole issue came up. It wasn't solely that. And then in the context of that, DHCR itself said payroll records weren't required in that context because this is my situation is a contractor has employees and they ask for those records. The employee is not an employee of the landlord or management. It's an employee of the contractor, and they don't require that, and they didn't require that in that particular case.
Okay, you have time for rebuttal.
Thank you.
Good afternoon. May it please the court, my name is Sandra Joseph. I represent the New York State Division of Housing and Community Renewal.
Good afternoon. So would you follow up on the point just made by your friend? Is it that you wouldn't require payroll records and specificity as to the work that's being done, that's being paid for?
It depends on the situation, on the fact pattern. In this case, because there was an identity of interest that involved the contractor with the owner, and the tenant presented evidence that this particular contractor was a principal of the owner. It goes back to 2010 when the principal signed a notice to the tenants about a matter. The principal that's involved in both the contractor and the owner also signed the organization papers, and I must confess there was a mistake made when it was quoted where they were found in the return, because I checked that today and they were in a different place, and I apologize for that. But that's the reason, even the lower court found there was an identity of interest. What the lower court didn't find is that the rent stabilization law provides that there's a burden on the owner to show that they weren't willful. Willful can be a situation where the statute actually provides that if the owner refunds the money, admits it did it, we won't charge treble damages. That's a statutory requirement. But in this case, the lower court just said, well, there's an identity of interest. However, I'm not finding treble damages.
Well, how about the case where there's no doubt that the repairs were made?
I'm sorry?
The case where the repairs were made
So matter,
or substantially completed.
right,
Yeah, well,
matter of Anthony Lauto, L-A-U-T-O et al. In that particular case, you found that there was no willfulness, where the inspector confirmed that 18 out of the 21 improvements on the invoice were made. And here, the inspector found that most of the claimed work had been performed.
well, even if they were done, it's about who paid for them. Because as the lower court said, it's for the owner to pay for them to meet the regulations. And in this case, there's a question mark as to really who did the work in this apartment. It's not the question in an identity of interest pursuant to 90-10 whether the work was completed. It's who paid for the work. And
Right, but we're talking about the treble damages now because you mentioned willfulness.
Right.
And so the question becomes, the other case, you found that there was no willfulness. Here, you find that there was, and so they are similar in terms of the basis. Appears to be similar for the basis, because in this case, you didn't even explain why there was a difference between this case and the Lauto case, L-A-U-T-O.
But in 125 Jane Street, which is similar to the case at bar, there was an identity of interest, and this court still found treble damages were warranted in that case because they didn't produce the proper documentation as the owner didn't produce here. So it's the statutory definition of willfulness, and the court below didn't even go through an analysis as to why it wasn't willful.
But in this particular case, the only reason that stated, apparently, for your finding that it was willful was the fact that not all of the improvements were confirmed.
It's same in this case, all the improvements weren't performed.
But in the other case, you had 18 out of 21, and you said that was fine. In this case, you have the majority being fulfilled, and you're saying that it wasn't fine and that it was willful.
Well, it was more so because of the identity of interest. You couldn't determine who actually paid for the improvements. Was it the workers as part of their duties that they had to renovate this apartment, and the owner expended no additional funds to perform the improvements.
Thank you. You do have time on rebuttal, right? Yes.
With respect to the issues my friend has raised, I do want to point out in the 125 St. James case, there was also an issue in that particular case with a total lack of documentation and a finding that the work wasn't done. Here, as Your Honor has pointed out, there was an inspection. DHCR went to the apartment and looked through the entirety of the apartment and found all but 2 things were not performed, which accords with the Lato case. And I cite to there's at least 3 other cases that have a similar finding where if the landlord can't provide the documentation, if the work was actually done, then DHCR does not find a willfulness and therefore does not impose treble damages. I also cite to another couple of cases, matter of Claremont and matter of Mitchell, which provide that if the owner reasonably believed that they had sufficient proof and it was determined otherwise, willfulness is disproved. In their argument, the record is in the briefs, in the DHCR proceeding, in the Article 78, they don't really explain anything as to the treble damages. And as to the reasoning, I made a motion with respect to this. They sort of bring it up on reply in their reply brief as to why they had these reasons, but they didn't explain it. So that is, I think, an error automatically. And just the Supreme Court did address a lot of these issues. We had extensive oral argument about that.
I want to go back to what the attorney referenced about the principal's involvement in 2010 and 2013. Right. My question to you is, did the owner ever address that below? Because there were documents showing the involvement. Was there any explanation regarding
There was documents in the record. There were affidavits provided twice, 2 affidavits provided in November of 2021 and 2 affidavits provided in November of 22. I believe it was 148, 149 in the record, and 174 and 181 in the record, where they addressed the issue of whether the relationship between the parties, and there's Oren Management LLC, Oren Management Corp., and Stevens, and that all those issues are addressed.
Thank you. So I did not see that an explanation as to the basis for the treble damages and the willfulness.
Well, in the power order, it specifically states, that the treble damages was imposed because it's the owner's burden to show that it wasn't willful. It's not our burden or DHCR's burden to show that this is why the owner was willful. It's statutory, again, that it's for the owner to show that it's not willful. And in this case, they clearly didn't do it. Even there's no case that says, well, if you perform the renovations, the IAIs, then you're not willful. It still could be, some of these were denied, even if you took it on that basis, those renovations would still be willful because the owner failed to show that it wasn't its burden. It was its burden to show that it wasn't willful.
But doesn't that constitute something that's arbitrary and capricious if you could say, well, you know what, here it was okay, there it was okay, there it wasn't okay, and in this particular case it's not okay, without giving any basis for this?
I have to be honest with you, in that particular case.
Please be honest. We always ask that the attorneys be honest. Thank you. And everyone be honest. We appreciate the honesty.
But it could have been a different fact pattern. I don't know, to be quite honest with you, I don't know the exact facts of that case. There may be something in there why they decided, maybe there was a refund, maybe there was something that the owner did to show that it wasn't willful. I have to be honest, I don't know the answer to that question.
Thank you. Thank you both. Delvey, the Archdiocese of New York.
May it please the court, Henry Masha of Rivkin Radler, attorney for the defendant appellant, the Archdiocese of New York. The Supreme Court order in this case emanates from a fundamental misunderstanding about the relationship between the Archdiocese and Our Lady of Mount Carmel School. The Archdiocese is an ecclesiastical body that exists to promote the Christian faith. And one way that it does that is by providing advice, support, and resources to the more than 250 Catholic schools and even more parishes within its territory.
I think that one of the issues was the kind of inconsistencies or contradictions, I guess, in terms of who did what, right? Because you had the representatives from the Archdiocese, one testified that during the period of the school's custodian and the coach, during that period, the pastor made all decisions for the school, and therefore the Archdiocese had no authority over the pastor. But then you had witnesses who also testified to the fact that the Archdiocese had the ability to appoint, remove, or transfer the pastor. And then the principal, who was ultimately hired by the pastor, came from an approved list of candidates who were vetted by the Archdiocese. The principals were subject to the guidance of the Archdiocese, and the Archdiocese also conducted the principals' review and recertification process. So there seems to be some, at least issue as to exactly what authority the Archdiocese had over the pastor, who had authority over the principal and the coach. I think that was the issue. It wasn't clear.
Yeah, I think the record is, I would say the record is undisputed about what the Archdiocese's role was at the time. The Archdiocese appointed the pastor, and there was a list, and could transfer the pastor. The Archdiocese had a list of approved principals from which the pastor could choose.
Right.
The Archdiocese would appoint someone, but ultimately the pastor was responsible for signing off on whether that principal would be brought on. And it's undisputed that all of these individuals were employees of the school and the parish.
But the Archdiocese also had the, I want to say the authority, but the Archdiocese also conducted the review, right, of the principal and recertification.
Absolutely.
So does that not mean that the Archdiocese has authority over the principal?
No, not at all. That's mostly.
They conduct the principal's review. They conduct the principal's recertification.
Right.
So if the Archdiocese makes a determination that the principal gets a negative review or is not going to be recertified, is the principal then not going to be removed?
Whether to keep the principal is the pastor's decision. If the ultimate, and the record is undisputed about that. And that's important because
I'm sorry, whether to keep the principal is the pastor's
decision.
Excuse me?
Pastor's decision.
But the Archdiocese is the one that's conducting the review and the recertification. So you're stating that even if the Archdiocese, whom employs the pastor, right?
Right. So no, the Archdiocese does not employ the pastor. The Archdiocese appoints the pastor to serve at a particular parish, but
so
doesn't
you're
employ
stating
them.
that the Archdiocese conducts the recertification, conducts the review of the principal, and if the Archdiocese determines that that principal should no longer be, the principal does not pass the review and should not be recertified, that regardless of that, the pastor is going to say, principal, you stay?
Well, we're mixing two things there. There's the reviews, but then there's also recertified to put the principal on the list of approved candidates, that if the principal is not on that list, then they can't serve in the Catholic Church. That's
So
true.
the pastor controls the parish, right?
The pastor.
The pastor does.
Right.
And who controls the pastor?
Nobody. The pastor.
The pastor is free to do whatever he wishes to do?
Yes, that's what the
Can the
testimony is. that
pastor say,
is
I am no longer going to tend to the flock at this church, I'm going to go up the street to the parish up the street?
The
answer
pastor
is
cannot
no.
just change,
The answer is
change
no.
parishes. No.
Yeah, that one's
no.
that
That's right.
right. And who decides where the pastor is going to be assigned, and if that person is going to be the pastor?
The Archdiocese decides that, absolutely. And that's not all that remarkable because religious organizations choose the individuals who will be the leaders in
Right, but all
doctrine.
we're trying to determine is whether the Archdiocese has any authority over the pastor who has authority over the principal. For us math majors, it's A equals B equals C.
I disagree with that though, because the standard that the plaintiff has to be met here for there to be an agency relationship is that the principal has to control the daily activities of the school, and the record's undisputed that didn't happen.
Right, but as I stated, I think the record is inconsistent. The record before us now maybe is inconsistent, at least in my mind, is inconsistent as to exactly what the relationship is. So at this point in time, maybe it needs to be fleshed out a little bit more, but it's a little contradictory, at least as I see it. But we'll hear from your adversaries and your friends, and you have time on rebuttal.
Thank you. May it please the court. Jeff Herman from Herman Law. I think my friend actually made a lot of points that I would make, which is that the pastor is hired, fired, supervised, all by the Archdiocese. The pastor reports to the Archbishop, and so he's under their control. That makes the pastor the agent of the Archdiocese of New York. And as the record shows, numerous reports of abuse were made to the pastor.
Sir, but what is the test for vicarious liability? Because your friend said it needs to be daily control or oversight, whereas it
I'm not
arguably
familiar.
didn't rise to that level.
Yeah, I don't think that's the standard. It doesn't have to be daily control of the school. The first question is whether or not the pastor is an agent of the Archdiocese. And the test is whether he's subject to their control, or they have the ability to control the pastor. The record is full of facts that suggest that the pastor is subject to the control of the Archdiocese, as I said, for hiring, firing, supervising.
Yeah, but I understand that, but your friend is also arguing or stating that the pastor is autonomous in making determinations as to the principal and the school.
No, that's not true. The record shows that the pastor can only pick from principals that are approved by the Archdiocese first. The Archdiocese has an entire Department of Education under their realm. They have a superintendent. It's an Archdiocese employee. That superintendent oversees the school and oversees the principal. That superintendent, before a principal could ever be hired, has to interview and give the thumbs up for the principal. And then the pastor
So if the Archdiocese conducts its review and determines that the principal doesn't meet its whatever the requirements are, in order for that principal to be recertified, does he or she have to appear on that approved list of principals?
Yeah, so to be hired, they have to be on the...
Be hired, yes. What about...
To be recertified, I believe, and I'm not positive, but there is a process that they have to recertify them. I don't think the pastor could hire them if they weren't recertified, but even if they could...
That's what I was getting at, right? Because so if the Archdiocese doesn't recertify the principal, does the pastor still have the authority to appoint the principal anyway?
I don't believe so, but even if the pastor did, the pastor is still subject to control of the Archdiocese, because the Archbishop could say, wait a minute, you're hiring a principal we don't like, you're out, we're moving you. And they do that all the time.
Let me turn on my mic, okay. Actually, I think that was questioned. I believe that there was a question posed to one of the sisters, and as to whether or not a pastor could remove someone who sexually abused children. And she said he could, but if he disagreed, then the archdiocese would get involved, reach out to the superintendent, and have him removed, would do what needed to be done. So,
Well, the sister who was the first corporate rep was not prepared to testify, which is we got an order to have another corporate rep, and that was Bishop Walsh. And Bishop Walsh, who represented the Archdiocese as their person with the most knowledge, testified that everything is controlled by the Archdiocese. The pastor reports to the Archbishop. And he also said if there's allegations of sexual abuse, they invite the parishioners to report it to the Archdiocese. They assume that investigation, which is really what's at issue in this case.
Right, well, that was one of the things also, is that parishioners could, in fact, make complaints to the Archdiocese about various things, including, I guess, sexual abuse, and then the Archdiocese would investigate those complaints.
Absolutely. And all that shows control. It shows that the Archdiocese does oversee the operations overall of the church and the school. It all comes down really starting the pastor who reports to the Archbishop. He's subject to the control of the Archbishop.
But is there too much attenuation between the Archdiocese on the one hand and the janitor / coach on the other?
Right. So the pastor, who's appointed by the Archbishop, is responsible to hire and supervise the janitor. So it's in the chain ultimately to the Archdiocese, so that when the pastor receives a report that the janitor is molesting kids, that because the pastor is an agent of the Archdiocese, that knowledge is imputed under New York law to the Archdiocese, their principal, and as their corporate rep said, he should have been removed, at least investigated, and that should have been reported.
How do we get, I understand the pastor. How do we get the janitor / custodian, where the pastor has the ability and the autonomy to hire whomever he wishes to do so, without any vetting or any list or anything like that from the Archdiocese? So how does the custodian fit into this?
Okay, right, because this is a negligence case. And so we're looking at, the question is, was the pastor negligent in protecting this child? And the question is, or the facts are, that the pastor received notice that one of his employees, it doesn't matter who, was molesting kids. The principal also received notice. Because the pastor is an agent of the Archdiocese, the knowledge that this janitor is molesting kids is imputed to the Archdiocese. Whether he reports it up the chain or not, it doesn't matter under New York law. The principal is now responsible. They have that knowledge imputed to them.
Thank you.
Thank you.
Thank you, Your Honor. I have to correct a few misstatements. The Department of Education, first of all, is an advisory body. And Sister Patricia testified that if there was some report about misconduct or child abuse, that the Archdiocese and the Department of Education would advise the pastor on what to do.
And we're talking about the Department of Education within the
Correct.
Archdiocese.
That's right.
Okay.
Which is an advisory body, and she testified repeatedly, and the record is completely uncontradicted that the Department of Education is an advisory body, and the pastor has autonomy about how the school is run, and that's the critical question. The other thing that I'd like to mention is that outside of the religious context, merely appointing somebody to do something is not enough to create an agency-principal relationship. That's a fiduciary relationship. And merely appointing someone to do something is not enough. And I'll give you a few examples. One, in the commercial context, when a parent and a subsidiary are alleged to be parent, principal, and agent, the test is whether the parent controls the daily operations of the subsidiary. And likewise, on the other side of the continuum, when you have a independent contractor situation, this court has said that when an individual is designated as an independent contractor and they maintain control over how the work is done, the person that hired that is not an agent. And that's the rule in the commercial context. It should be no different in the religious context.
Well, I think that's the issue. The issue is whether we can determine as a matter of law that there was no agency, that there was no, that there was not the agency relationship.
Right, but it's undisputed that the pastor controlled the day-to-day operations of the school and the arch didn't. And with regard to apparent authority, and I can't leave without saying this, the letters that were submitted, the complaints, they actually illustrate that point. Because the individuals complained about, as you said, a whole variety of things. They said bingo night was too cold, it was dirty, all these things, not enough toilet paper. And so, but all the complaints focused on the pastor at the time was the one who caused this. And the people who complained, they didn't say, Archdiocese, can you send us toilet paper on bingo night? Can you send somebody to clean? Can you send a janitor to clean the school? They don't say that because they know that the pastor is responsible for the day-to-day operations and the Archdiocese is not. So there's no apparent authority. There's no authority at all, and there's no agency at all between the Archdiocese and the school. And that's why Supreme Court should have granted summary judgment.
Thank you. People v. Shaquille Dinkens. Yes, you may proceed.
Good afternoon. On behalf of Shaquille Dinkens, Phoenix Rice Johnson. This is a straightforward case. Mr. Dinkens repeatedly attempted to speak with the court and he attempted to tell the court, I need a new attorney.
He said, I need a new attorney, and then afterwards, he stated that the attorney did not, he said, I need a new attorney, several messages, not answering the phone, several emails.
Correct. And before he was able to complete his statement, because that appears to be an incomplete sentence, the court interrupted him and told him, you have to stick with this attorney. And then Mr. Dinkens emphatically reinstated his need for a new attorney, saying—
Counsel, that may be true, but the defendant then on a later date proceeded to take a guilty plea, and then on a separate date proceeded to be sentenced and didn't bring the issue back up. So didn't he waive it?
He did not waive it.
Why not?
The Fourth Department's case law on that issue is completely at odds with this court's and the Court of Appeals, both of which have vacated pleas where the client pled guilty.
Well, not even dealing with Wellington. Just in general, why did that not constitute a forfeiture or at least abandonment of his argument, of his claim?
Well, first of all, that is not this court or the Court of Appeals precedent, but more importantly, at that plea proceeding, Mr. Dinkens was never asked, are you sassified with your attorney's representation?
To some extent he was, because when the plea on the adjourned date, when they came in, the attorney stated, my client has authorized me to enter a plea of guilty to criminal possession of a firearm. And then the court says to Mr. Dinkens, is that correct? Do you want to plead guilty? And he says yes. He never stated, no, wait, I did not authorize this attorney to enter a plea for me because I don't want this attorney. I want another attorney. He never states anything.
Mr. Dinkens, at that original proceeding where he asked for a new attorney, emphatically and repeatedly asked for a new attorney, and the court rebuffed him and told him—
I understand that. Now we're at the time of the plea.
Right.
At the time, that's what I'm talking about, the time of the plea where the attorney says, my client has authorized me to enter a plea of guilty to criminal possession of a firearm. Mr. Dinkens never states, in response to the court's question, is that correct? He never states no. Was it not incumbent upon him at that time, if in fact he no longer wanted this attorney to represent him, to say, no, that's not true, I don't want this attorney?
It's not clear why Mr. Dinkens would think that was even an option after the court had told him, if you don't like this attorney, hire one of your own. The only option—
The court was free at sentence and at plea to inquire further, right? The court was on notice that the defendant at least had some issue with the attorney.
Absolutely.
And the court failed to make any inquiry, correct?
That's correct.
So what about—
It's common practice, I would say, that when you're taking a plea allocution, you do ask the defendant something about the relationship with the attorney, correct?
Correct.
That didn't happen here, correct?
Precisely, and especially here where Mr. Dinkens time and again said he could not do it with this attorney, he could not proceed.
I don't know that it's time and again. It wasn't time and again. It was twice, I think, he stated it, and it was kind of muffled together. So to follow up on my colleague's point, So at the plea, he doesn't say anything. The entire colloquy, he doesn't state anything where he's asked whether or not he discussed the plea with his attorney, whether he discussed the waiver with his attorney, whether he went over the waiver with his attorney. At no point in time does he talk about how he no longer wants that individual as an attorney. Then we get to sentencing. Are you ready for sentence, etc. He never states at sentencing that he did not want to go forward with the sentencing. He did not want that attorney.
No.
So again, there's no point in time in the proceedings where he should say, look, I told you I don't want this attorney, and I don't want him representing me for purposes of the plea or purposes of the sentence.
To clarify, there was no appeal waiver here.
I'm sorry?
You mentioned a waiver. I just wanted to clarify. There was no appeal waiver here, if that's what you're referencing. I wasn't
Well,
sure.
there was the colloquy, right?
The court made clear there was no appeal waiver because he was pleading to the only count in the indictment. But regardless, Mr. Dinkens had no reason to think this court would be receptive to additional information after it told him you have to stick with this attorney or hire one of your own.
And that's based on what?
He may have been under the false impression that if he continued to raise this issue, he would have to proceed without counsel or somehow find the money to hire one when he couldn't. It's also worth noting, as my adversary pointed out in their briefing, that when he was no longer appearing before that same judge that rebuffed him, he actually did file a 440 in which he raised additional issues with counsel. Thank you.
Thank you.
Your Honors, and may it please the court, Anna Notchik for the people.
So we do you concede or agree that the judge should have made further inquiry of the defendant in terms of exactly what his issues were with the attorney?
No minimal inquiry was required here. A minimal inquiry.
Let's go through what happened at that first proceeding, right? So that first proceeding, the defendant walks in and says that he wanted to approach the bench, right?
That's correct.
That's an indication that I don't think he meant literally he wants to come up to the bench. He wants to have a discussion with the judge, right? Do we agree on that?
Okay, yes.
Okay. So then at some point the judge didn't follow up on that, right?
Yeah, there is nothing in the record to show that the judge responded to that.
So then at some point the judge says, speak with your attorney. And the record is also unclear as to what prompted the judge to say that, right?
The record is unclear about
Right.
that.
So presumably when you say speak to your attorney, it's because something happened that maybe the defendant was trying to get the judge's attention, raised his hand. Clearly, something prompted the judge to say, speak to your attorney. And that's when the defendant says, right, the complete statement is, I cannot talk to him. That's why I'm talking to you. I need a new lawyer. Several messages, not answering the phone, several emails. At that point in time, the court goes on to say about how great this attorney is, how he's busy, he's a good lawyer. If I give you another lawyer, that lawyer is going to be just as busy or busier. So basically, this is what you got. The defendant says, I cannot do it with this attorney. I'm sorry. And then the judge ends it by saying, then you hire one. This is so presumably an indigent defendant who already has appointed counsel, correct?
That's right.
So at that point in time, it's your position that the court had no obligation to ask a further question as to why was it that he thought that he could not speak to his lawyer?
No, Your Honor, because
Why not?
a minimal inquiry is only required.
He did not give him an opportunity to explain it.
But before a minimal inquiry is even required, a defendant has to make specific factual allegations about seemingly serious issues with counsel.
I cannot talk to him, I think it's seemingly serious.
Your Honor, it doesn't suggest an irretrievable breakdown because there are other aspects of the record that show that there was.
What it is, counsel, that we don't know what he meant because the judge didn't take the opportunity to ask one question.
He didn't have to, Your Honor, when there were other
That's where we disagree.
There were other parts of the record that undermine the defendant's
Like what?
claims. Like the fact that counsel had filed an omnibus motion that specifically said it was based in part on conversations with the defendant, so they were obviously communicating.
So what? So the breakdown could have happened afterwards.
Well, Your Honor, also...
The breakdown could have happened that morning.
Well, Your Honor, the defendant and the attorney had clearly spoken because he was representing defendant on a...
Another thing, when the judge tells the defendant, speak to your lawyer, does the judge follow up with the lawyer?
No, Your Honor, but again...
Does the judge follow up with the defendant?
He didn't,
The judge did nothing, correct?
Your Honor, the judge...
At that point in time, what did the judge do to follow up to see what was the defendant's grievance?
Your Honor, the judge explained to defendant all that his attorney had done up until this point, which this is only...
Where's that? I don't see that in the record here.
Your Honor, the judge says your attorney has filed motions. Motions have been granted because of that. This was only the appearance after a...
How does the judge know that that was responsive to the defendant's issue when the judge doesn't know what the issue was?
Your Honor, the defendant has to make some specific factual allegations about an irretrievable breakdown in order to warrant a minimal inquiry. But even if we can agree that a minimal inquiry was required, defendant forfeited any replacement of counsel claim when he later pled guilty
Well, that
to
depends
the
on who you want to
statutory...
place the burden on. If you want to place the burden on a non-lawyer defendant that's standing in the position of not having power before a justice, or you want to put it on the justice to say, you know what, you brought this issue up before, so because it's incumbent upon me to see if your plea is voluntary and intelligent and free, maybe I should ask about
Which
that.
the defendant doesn't claim that his plea was anything other than voluntary at this point, just to be clear. But at that second appearance, the judge said, your attorney just said you want to plead guilty. Is that what you want to do? The defendant could have said, no, I haven't spoken to him. But
Maybe the
didn't.
defendant did want to plead guilty. I don't understand why a defendant that doesn't want this attorney representing him all of a sudden has to say, I don't want to plead guilty. Maybe that wasn't his best interest. You're mixing the two.
But the fact that it's in his best interest, that's why you waive non-jurisdictional claims when you plead guilty. And this is a non-jurisdictional claim that does not survive a guilty plea. That's why this should not be reviewable on direct appeal. And even if it is, we do not believe that a minimal inquiry was required.
I wanted to get back, I'm sorry, go ahead.
You sure?
Yeah, go ahead.
Okay. Is there any tension between your argument that the judge had no obligation because the facts necessary to trigger the minimal inquiry had not been adduced? Is there any tension between that argument and our decision in McCummings and People versus William Rodriguez?
Your Honor, I'm not at this point exactly familiar with the facts of this case, or those cases, but I will say that there is a case. I'll point to Divine Fredericks, which was a case out of this court that then got affirmed at the Court of Appeals, where the defendant said something like, it was a lack of communication.
In Fredericks, isn't the distinguishing fact with Fredericks that Fredericks wrote a letter in that case, right? Fredericks had the opportunity to include in that letter whatever it is whatever gripes he had. So he had the opportunity to establish the serious problem between him and counsel, and he just failed to do that. In this case, arguably, the defendant was not given an opportunity to explain.
The defendant could have written a letter, Your Honor.
Or he could have written a letter. I'm sorry, he should have known that.
Well, Your Honor.
As opposed to speaking to the judge directly in front of him at a proceeding.
Your Honor, but I will also point to, in Divine Fredericks at the Court of Appeals, the Court of Appeals didn't necessarily use that in their determination that a minimal inquiry was not required. They said what was alleged in the letter wasn't sufficiently serious, and it was undermined by other parts of the record, and that's exactly what we have.
I'm not disputing that the determination that what he ultimately raised would not give rise to an inquiry, to the duty to inquire. That's not what I'm disputing. What I'm disputing is comparing apples to apples, in that in Fredericks, the defendant had the opportunity to plead his case in the form that he did, as opposed to here, where he was shut down by the judge.
Well, Your Honor,
or at least arguably shut down by the judge.
Arguably, because again, this is on appeal. We have a record. This is why we give some discretion to the judge. We can say that the judge cut the defendant off, but we don't know, because we don't know what
the judge did bottom line. He says, then you can hire one.
After the judge explained to the defendant why his attorney was doing a good job. But again, I just want to emphasize that defendant could have re-raised this and could have chosen not to plead guilty to the statutory minimum.
I wanted to ask a question. I had two questions. I forgot what the second one was, but maybe I'll think of it. I did note in the record that this attorney did represent the defendant on another case.
Yes.
Was there anything in the record as to whether he continued that representation of the defendant in that second case?
Your Honor, it's not in the record, but...
Well, then don't speak about it.
Right.
And then the other thing was, your friend made reference to an appearance before a second judge and 440, or made reference to a 440. Was there ultimately a 440 for ineffective assistance of counsel? Or
there was
a
440 made. There was no, it was denied, and there was no 460-15 filed, so none of the 440 records are part of the record on appeal. That would have to be a separate appeal here, but there was no 460-15 ever filed.
But there was a 440?
There was a 440 that was denied.
And what was the basis of the 440?
It was not lack of communication. It was...
in the record?
No, Your Honor, as I just mentioned.
Oh, okay, so your friend made reference to something that wasn't in the record.
Well, Your Honor, just so that the court could fully understand all the facts. We did note in our brief that the defendant did file a 440 on ineffective assistance of counsel grounds, but the actual facts of that 440 and the underlying decision are not part of the record.
Thank you. And the 440 was made before this same judge, is that correct?
Yes, and it was denied in, I believe, March of this year, and there's been no 46015.
Thank you.
Thank you.
There seems to be an interest in why he did not request to withdraw his plea during the plea proceeding. And I just want to make clear, based on the communication that he had with the court, what he may have been under the impression of is if he said, I don't want this plea, he would have just gone back to continuing.
See, that's the problem that I have. You know, it's speculation. I mean, again, I don't know why he did not say, again, when he had two opportunities to do so, I don't know why he did not say, I don't want this attorney. I mean, it seems to me that he had ample opportunity to do so. And I recognize that there may be an argument that, you know, it wasn't incumbent upon him to do so. But it seems to me, again, where he once stated something, if he was not comfortable with this attorney, that he would say something. And I think it's speculation. Oh, you know, he was shot down and therefore he's, you know, he's trembling and he doesn't want to say anything to this, you know, this individual who has power. I don't know that I understand that argument, but I don't know that it fits the facts here. Something that your friend did mention is that there's no issue in terms of the voluntariness of the plea, right? He's not in any way stating that he was somehow coerced or that the plea wasn't voluntary, right?
That isn't necessary here because where the court fails to conduct a minimal inquiry, which it didn't here, then vacatur is the appropriate remedy, at least based on this court's precedent. I also wanted to note that this is a pro se applicant, right? Which is why the minimal inquiry is so important. A pro se applicant is not an attorney who always—
I'm sorry, it's a pro se applicant.
The defendant here made a pro se motion, for new counsel. A pro se—
Pro se, you're speaking, when did he make a pro se application for new counsel?
He made the application on his own without the benefit—
He was represented by counsel, so he's not pro se.
All right, but counsel did not say, my client would like a new attorney and here's why. That's why the court's minimal inquiry is so important, is to understand the underlying basis, because he may not have been as well possessioned as someone who—
To some extent, I think that may undercut your argument, right? Because if he's pro se, he's making a pro se application and he knew to make this application, why did he therefore not, again, make it on the two later occasions?
Just because the facts make clear that he was likely under the impression he would have had to hire an attorney of his own. He would rather take a plea deal—
Or could it just be that it was denied?
Certainly, it was denied again and again. Thank you, Your Honor.
It was denied once.
He was told, you have to stick with this attorney.
Yeah,
he renewed his
was
request.
told, you have to stick with this attorney. He's very good, I'm telling you. He says, I cannot do it with this attorney. I'm sorry. The court says, then you hire one. This is one interaction between the court and the defendant. It is not denied again and again. It's one denial based upon the statements made by the defendant. I'm sorry, Justice Shaquille?
Just had one follow-up to something your friend said, and if I hope I understood her correctly, that by virtue of the guilty plea that was taken, any claim along these lines was forfeited.
That's incorrect. That's inconsistent with this court's case law and the Court of Appeals case law. In both of those precedents make clear that when a defendant makes a request for new counsel, even when he is later represented by that same attorney at the plea proceeding, that request for new counsel claim still stands, and there have been vacatures under those same fact circumstances.
So have those cases specifically stated that it does not constitute forfeiture?
I don't have those cases in front of me. I provide a list of them. Sides is a case where the client ultimately pled guilty with the same attorney about whom he made an earlier request. And I believe I cited to a case in this court where the client made a request for new counsel at a suppression hearing and then later pled guilty with that same attorney, and the court vacated his plea. So clearly there's precedent for providing this type of relief.
Thank you.
Thank you
both. Uno, a Brokerage versus Insure. Yes, please proceed.
May it please the court, Stephen Kalina, Cox Padmore for the appellant, Unaway Brokerage. Your Honor, in this case, the trial court erroneously dismissed the complaint before it on statute of frauds grounds, specifically under General Obligations Law 5-701A10 and A1. We respectfully submit that that decision was an error. And I'll just focus my comments on those two primarily at this moment. The nature of this action is not the kind of a nature that the Supreme Court reconstituted as principal and broker. This was not an intermediary situation where our client, Unaway Brokerage, was making an introduction. Quite the opposite. And with respect to the arguments we raised in our brief regarding the introduction of the draft producer agreement, but even looking at that agreement, and more particularly the allegations pleaded in the complaint, these parties were working together to place insurance as brokers. And the record is clear. There's joint marketing provisions. There's sharing of commission provisions. There is regulatory provisions about maintaining licenses, and even to go so far as to maintain errors and omissions insurance.
They agree to share losses?
They did. Under section, and I'll point Your Honor to it, I believe it's 2.5, the draft producer agreement says that the producer, our client, shall ratably refund to the general agent commissions on canceled policies. So when the structured commissions come in based on placements, Unaway Brokerage shares in that commission. When a commission is then, a policy is canceled or non-renewed, or whatever the particulars are, then there's a refund required by Unaway Brokerage. So the extent to which this is akin to a joint venture, in terms of sharing resources, profits, and losses, then there are facts before the Supreme Court at the dismissal stage that should have warranted moving this case forward into discovery. The defendant is not prejudiced by being able to defend the case and perhaps fleshing those facts out. And just to jump, if I may, to the issue of dismissal without discovery, contrary to the respondent's brief, it's not a fishing expedition because the discovery here the request for discovery would match that which is pleaded in the complaint. There are wire transfers pleaded in this complaint of commissions paid to Unaway Brokerage. The notion that the respondent would be wiring monies, commissions, under an agreement without any other writing, without any other authorization that may come together with the draft agreement to suggest as an enforceable writing, again merits moving the case beyond dismissal, the dismissal motion, based on issues of fact and based on the allegations pleaded in the complaint. And if I can just move briefly in my time allotted to A1 with respect to whether the agreement was performable within a year. The facts, again, before the court, because the court looked at the draft producer agreement, are clear that there are termination provisions well within the year provision. The standard is it conceivably be performed within a year. And those termination provisions clearly make it conceivable that it be performable within a year. Again, those allegations and the facts before the court warrant moving this case beyond the dismissal motion and having discovery on these issues, but to ipso facto dismiss it for statute of frauds was premature and was error. With respect to, if I can just illuminate for a moment, on that point, I'd like to draw your Honor's attention to the JF Capital case, which makes a distinction between whether someone's participating to negotiate a fee and whether they're participating in the furtherance in the negotiation of a fee. And again, there are facts in the complaint, and the court considered, again, subject to our arguments on the draft producer agreement, and the JF Capital case uses the term braided claims when there are facts that show participation. And here, the producer has to submit the insurance that the general agent, the appellant, has the opportunity to reject it and that the general agent is relying on the work, placement on forms, vetting the information that the appellant brought before the respondent to make a decision whether the respondent, I'll finish up, I see my red light is on, to place the insurance. There's nothing before the court that would suggest that this complaint should have been dismissed so summarily without any discovery on the issues of the statute of frauds. We stand on the balance of our arguments in our brief subject to rebuttal. Thank you.
Thank you.
May it please the court, Tom O'Connor of Fox Rothschild for respondent Insure Inc. Your Honors, the claim pleaded in this case is that Uno A Brokerage entered into an exclusively oral agreement with Insure to go out and use its know-how and know-who, that is, its contacts within the rideshare industry, to obtain potential customers and refer them to Insure. In exchange for doing that, it was to receive commissions based on, again, an exclusively oral agreement on a prescribed schedule,
Right.
based on the
commission
volume.
is going to be split between the two, right?
No, Your Honor. There is nothing in the record to suggest that there's any splitting of commissions here.
So how then would this be a joint venture?
It cannot be a joint venture, Your Honor. This has none of the hallmarks of the joint venture. Justice Borak covered this extensively in his opinion. We've covered it in the briefs. But if I direct Your Honor's attention to the actual producer agreement in the record, particularly page 26 of the record and section 2.1 of the agreement, there it provides not that there will be a sharing of commissions, but that the plaintiff in this case will receive a commission for the volume of business referrals that it gives to Insure Inc. This is
Anything as to sharing of losses?
No, Your Honor. In fact, what the agreement provides is that Insure Inc., or rather Uno, the plaintiff, will be exclusively responsible for all of its costs, all of the costs that it incurs in going out and trying to find these business opportunities. So there is no sharing of losses under the agreement. It's a one-way agreement. This is in stark contrast, Your Honor, to the situation where in Dura, for example, the court had found that where there's a joint venture between two finders who are acting for a common principle to go out and find business opportunities and refer them to the commission, to the principal, where there's either a sharing of losses.
Right, well, Dura kind of spoke about a finder's fee, right?
Finder's fee. This is not that, right?
And then you made reference to this earlier in your argument, the fact that this is an oral contract.
That's right, Your Honor.
And so your friend made reference to the fact that it could be completed within the 1 year period of time.
Yes, the court doesn't need to reach the 1 year issue because this contract is barred under two independent sections of the statute of frauds, right? It's a commission agreement and barred under A10, and because it can't be performed within 1 year under A1. On the 1 year issue, Your Honor, that you've raised, we've been through this in the papers, but there are multiple sections of the alleged oral agreement that specify that there will be post-termination obligations. I'll point to one. There's an indemnification obligation. I'll point to another. There's a right of first refusal that Uno had granted to Insure that also would continue afterward. So these are the kinds of obligations that this court has recognized fall within the 1 year statute of frauds. And an important point, Your Honor, is that if any section of the agreement, that is, if any of the terms of the agreement are barred by A1 of the statute of frauds, the entire agreement is barred. That's why the court has seen arguments in the papers about the agreement being severable, but in fact, it is not. It's an oral agreement based on the terms of this document alleged, which we have to assume for purposes of this motion, but all of these terms work together, right? So that they're not capable of being severed. I do want to touch on the discovery issue because counsel had indicated in his remarks that this is all premature. Although they've alleged that there's this agreement whereby their client will go out and obtain or use its contacts within the rideshare industry to refer business to our client, that perhaps they should be allowed to fish around to see what they can find. Perhaps there is a writing somewhere. What they're asking this court to sanction and what they're asking the trial court to sanction is a fishing expedition for a document that is a writing that would satisfy the statute of frauds, but they've alleged that there isn't one, right? They've alleged that this is an exclusively oral agreement. With my remaining time, I just want to focus the court on one issue, which is the crux of the arguments on appeal. That is, all these arguments on appeal really flow from one point in the brief. They've asked this court to find that the trial court erred in considering the draft producer agreement because it was appended to an attorney affirmation, right? What they've missed here is that, yes, the document was submitted in support of a motion to dismiss, appended to an attorney affirmation, but the principal for the defendant admitted that it appeared to be the document that was referred to in the complaint as the basis for the oral agreement, and then counsel expressly conceded to the trial court that this document was in fact, for purposes of the motion, to be considered the agreement. So the trial court didn't err in looking at those terms, and in looking at those terms, it found correctly, Your Honors, that this is an agreement falling squarely within the statute of frauds at A10 as well as A1.
Thank you.
Thank you, Your Honor. May it please the court. Just taking the last position first, both counsel and the principal of our client did not concede anything of the sort regarding the agreement. However, what they did say was, we've not reviewed it line by line. That's what they both said. And obviously, any litigant is constrained when it's presented with evidence to make the arguments it must before the court, but there was never a concession to take that off the table. The thing that I'd like to also address is that counsel for the respondent continuously elides over the termination provisions to reach those that might possibly take it out, as they allege or argue, out of the 1 year, the A1 1 year provision. But what counsel for the respondent is not looking at specifically are those severable provisions that instruct the court under Americana, Guterman, and Apostolos. And I would encourage the court.
The fact that we're talking about commissions and the fact that we're speaking about the defendant referring business for a commission, would that not take it into A10 and something that could not be performed? That something would have to be reduced to writing?
On the facts pleaded, not here. Dura discusses akin to a joint venture. Friedman cautions courts when it comes to the negotiation of a business opportunity to not get so specific about the parlance. Each industry is different.
Right, but again, as I think I mentioned, Duro talked about a situation where the commission is going to be split. Here, there's no splitting of the commission. Here, it's a straight commission relationship.
I mean, just 2.1 reads, and these are the facts, the producer commission shall only be paid on policies for which the general agent has already been paid. So the ability for the appellant to be paid is dependent on the respondent to be paid first. And
so you read that as a sharing of the commission?
I read that as a fact that, yes, when you read that in connection with, there is a section in the agreement for joint marketing where the parties have to work together to maximize the value of the agreement, share and work together to share their own names and service marks. So there are facts before the Supreme Court that it's just a commission agreement, just glosses over the very specifics of the agreement that the respondent put before the court. And so when the Supreme Court looks at it, they can't on one hand say this is just a broker principle, straight intermediary commission agreement in the traditional sense of that Dura and Friedman were looking at. When you look at the outside terms of, the full scope of the terms, there are terms that at least speak to losses, that speak to sharing of resources, talk about how commissions come in and when they are paid. And in the aggregate set of facts on a 3211A1 or 7 motion, there's sufficient facts before the Supreme Court. This motion was never converted to summary judgment.
Thank you. Thank you
Thank you
both.
very much.
People v. Daniel Newell.
Good afternoon. May it please the court, Elizabeth Vasily on behalf of appellant Mr. Daniel Newell. The trial court violated ORAMA by unilaterally responding to a jury note.
So the parties had agreed beforehand that they would send in, with the court, that they would send in any exhibits without requiring the permission or calling in the attorneys before doing so.
That's right, Your Honor, for unambiguous exhibit requests.
And what was unambiguous about a jury note requesting a video?
So the jury...
When this was, I believe, the only video of the incident at Duane Reade, was it?
That's right, it was the only video, but the note said we request the video of the defendant shoplifting.
Okay, so what's the problem with that?
They didn't say we want the whole video. We don't know which portion of the video, just the portions where he's grabbing the objects. And in this case, the video was only played to certain snippets to the jury at trial. So they only saw a few different portions of the video. So that required input from counsel. Do we give them the same portions that they saw at trial?
Was the entire video in evidence?
It was, Your Honor.
So whatever is in evidence, whatever is in evidence will be shown to the jury. I'm not understanding.
This is just like when the jury requests a readback of...
No, it's not, because the jury would say, I want a readback of the direct. I want a readback of the cross-examination. I want a readback only as it pertains to his going into Duane Reade, or it's different. And if there was any question as to the specificity, exactly what the jury wanted read back, then the court would obviously bring in the attorneys. Also, the attorneys would never agree to having readbacks sent into the jury without their being present. This, we have a specific note from the jury saying we want the video of the defendant shoplifting, and this is my colleague mentioned, this is the only video that was in evidence.
But at trial, they were only shown certain seconds.
But as my other colleague mentioned, the entire video was in evidence. So the entire video then would be sent into the jury room.
But because they were only played certain portions of it, it was unclear whether they wanted the whole video or just the ones that they were played at trial.
Would it have made any difference if the jury asked for the video?
Absolutely, Your Honor. If we said we want the video, or we want Exhibit 18, or if the jury said we want this, but because they said of the defendant shoplifting, and there was another question embedded in that note as well, which we're not contesting in this appeal, but because they did say we want the testimony of Letitia Brown when she testifies what she saw, and we want the video of defendant shoplifting, shows that they're at least for input. ORAMA is just a quick notice. All that needed to be said was to give the lawyer the opportunity. Do you want to direct the jury to certain timestamps? Should we just give them the whole video? Should we only give them the portions that are played at trial?
Did counsel object?
He did not object, but that's not required at this stage because the court already responded to the jury before giving notice to the parties. They sent in the video, and that was it. So at that point, there would be no objection needed.
And you're also arguing ineffective assistance to counsel.
That's right, Your Honor. On direct appeal, we are, yes. The counsel argued no defense theory in this case because there was a misunderstanding of the law, and counsel overlooked all that case law.
And that would be borne out by the 440?
It wasn't a 440 that we litigated.
So the answer is it's not borne out by the 440 because there was no 440, right?
Well, we did file a 440, but it was more of a McCoy-based 440. That was denied leave on 460-15. So we are raising this ineffective assistance of counsel claim on direct appeal because the record itself bores out that claim. But yes, it was also litigated in a 440.
The 440-10, didn't the defendant make the same arguments as being made here?
They were different. There was some overlap, but they were different. That was mostly a McCoy-based ineffective assistance of counsel claim that he conceded guilt without his client's permission.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Christian Rose for the people. With the Iran...
How do you respond to your adversary's position that the jury's note that we want the video of the defendant shoplifting, that's ambiguous? They don't really state what it is in light of the fact that they only saw snippets of it, that you just don't know what it is they want.
Well, two responses. The first is that just about the having only heard snippets of it, I think that they probably saw a substantial portion of the video. It's not clear from the trial transcript exactly where it stopped and started and what's played all the way through.
But the entire video is in evidence, right?
And the entire video is in evidence. It's just like medical records. A jury is not going to be interested in the vast majority of what's present in medical records. They're going to be interested in a few specific parts, but it's not required for counsel to go through and look at what parts of medical records it might be most interested in and only provide those. And I think it's kind of difficult to imagine a more straightforward exhibit request than Dwayne Reed video of the defendant shoplifting. That's what happened on that day. It's what defense counsel conceded had happened on that day, and it was obvious from the video.
Well, straightforward would have been, can we get the video? Because as Justice
Well,
Mendez stated earlier, there was one video in evidence.
Right. I mean, I think the only reason I say not in this instance is because there was a separate video of the incident at the precinct, and so maybe there would be some arguable claim that it might be ambiguous.
So there was a second video in evidence.
Yes, but it was related to a different incident on a different day. Okay. That was when the defendant snapped the plexiglass in a holding cell with his foot. Very different from the Dwayne Reed theft that preceded his lighting the shoes on fire in the Apple store.
So the inclusion of the shoplifting in the Dwayne Reed would have been to identify the particular video they wanted, as opposed to the precinct video.
And I think it's helpful, as my friend on the other side mentioned, to compare and contrast the difference between the testimony request in this case, or in this jury note, with the video. The testimony is Letitia Brown's testimony when she testifies what she saw. That is much less clear than asking for a security video from a particular store on a particular incident.
Yes, but your friend argues that that request also seems to perhaps narrow down exactly what portion of the video from Dwayne Reed they're seeking.
I don't think that's right. I mean, a jury could have requested both Letitia Brown's testimony about what she testifies when she saw and the video from the precinct. They could have been concerned about both issues. I think that maybe if we had had Letitia Brown's testimony and then the video, we might have argued that it was reasonable to assume that the jury was requesting the video from Dwayne Reed and not the precinct, but obviously that's not this case. I'm happy to discuss any other issues, and the ineffective assistance of counsel claims, as I think Your Honors were pointing out, is unreviewable for two reasons, both for the fact that there was a 460-15 that was denied, raising the same issues, and we're happy to provide the 440 papers if that's of any issue, but I don't think that there should be. And then also because the direct appellate record does not allow for sufficient review, especially when the basis of the ineffective assistance claims includes ideas that the defense counsel wasn't researching case law that in their view, hurt his defense.
Excessive sentence?
The defendant received a sentence that was 1 year over the minimum. He's now released on post-release supervision, and the Less is More Act will already have his term of post-release supervision if he abides by those terms. If Your Honors have any other questions, we ask that you affirm.
Thank you.
If this was a 2-minute video that was played in its entirety to the jury and then they requested the video of defendant shoplifting, then this wouldn't be an issue and that would be unambiguous. But because it wasn't that short and contained of an exhibit, it's not like the other case. This is different from the other case law. For example, requesting a diagram. We want the exhibit. Okay, here's the diagram. One simple exhibit, that's it. But when there's portions, when there's certain viewpoints, different things played to the jury, that requires notice because that's not unambiguous.
I could perhaps understand your argument if the fact that the entire video was not in evidence. If only snippets of the video was in evidence, then I certainly would understand, because then it would have to be the jury would have to be brought into the courtroom and those snippets would have to be played for the jury. But since the entire video is in evidence, I'm not seeing your argument.
If there's no further questions, thank you.
Did you wish to address excessive sentence?
Oh, no, Your Honor.
Thank you. Gu VG. Are we all on this case? I have the appellant was late.
I'm here. I'm not late.
Okay, you were late. Somebody was late. I only gave time to, I thought I only gave time to you. And then I was told that someone else was here, and then I was going to give time to them oh, I'm sorry. I see. You're both here.
May I proceed?
Yeah, you were late. I don't know. Okay, yes, please. I'm sorry.
Okay, good afternoon, Your Honor. I'm Appellant Fei Gu. May I please the court? So in this case, appellant was assaulted at the workplace, and appellant was raising wage theft and along with other cause of action against the respondents. There are two underlying appeals against each respondent, and I will address it one by one. So to start with, respondent G, appellant filed a motion for a partial summary judgment against Hongji as employer of appellant in the lower court. The lower court denied it in a very vague and conclusive order. The judge reasons that there's no evidence in support. However, this is wrong, and this is contrary to the record. Because in the record of the lower court, appellant has raised evidence. Appellant referenced the case in the federal court, EDNY Wing Chen versus Seafood Food. Seafood Food is one of appellant's workplace, and it also involves the same defendant, Hongji. So in this case, the judge rendered the fourth judgment against Hongji and adjudicated that the court has jurisdiction against Hongji because the judge adjudicated that Hongji has received the summons and complaint. And also, the judge further adjudicated that Hongji, the respondent G, was the employer of Seafood Foods, the same workplace that appellant worked. So because of this and because of other evidence in support, including the WeChat conversation and other documentary evidence, the lower court made a mistake which adjudicated that there's no evidence in support. And apart from this, appellant also want to raise this court's attention because in the lower court, appellant also filed a document notice of rejection. Respondent's affirmation in opposition was only filed 1 day before the return date, and then appellant filed notice of rejection. The lower court did not rule that whether the lower court has considered appellant's notice of rejection or not. But if for this court to consider, appellant requests this court to also reject respondent's argument because their opposition was late. Regarding another respondent Pang, respondent Pang did not file any brief, and respondent Pang did not appear today. So respondent Pang filed motion to dismiss, which was granted by the lower court. And appellant filed a motion for contempt of court against respondent Pang, but it was denied by the lower court. So to start with, motion to dismiss. The lower court reasoned that, well, respondent Pang motion to dismiss should be granted because appellant failed to meet her burden that shows, respondent Pang was the employer. However, the lower court was wrong because it was appellant Pang who filed motion to dismiss, and it was his burden to meet, it was his obligation to meet his burden. He only submitted an affirmation without any evidence. However, on the contrary, appellant had filed tons of evidence. Appellant filed the documentary evidence, including WeChat documents, linking profiles, which indicates that respondent Pang participated in the daily operation of the restaurant, which include cooking the food, delivering the food, and also sending the large delivery orders. And also, he even participated in the daily operation by supervising the restaurants. So a reasonable person can draw inference that, well, respondent Pang could be the employer of appellant. And by the way, as appellant has indicated that respondent Pang did not file any evidence, and he could not meet his burden. And as to appellant's contempt of court against respondent pound, because the lower court orders that respondent pound should answer the complaint in 20 days after the order, respondent pound did not file the answer. Therefore, he should be adjudicated in contempt of court, and because the lower court adjudicates that this case should be dismissed, and the contempt of court was adjudicated as moot. So this court should reverse the lower court's rulings. Thank you.
Thank you.
May it please the court, Your Honors. Robert Tracy from the firm Gibney, Anthony, and Flaherty for defendant respondent Hong Ji.
So the issue is, who is the employer?
Excuse me?
The issue is, who's the employer? Who is the employer?
Well, that's one of the
issues
issues, yes,
is who
Your
is
Honor.
the employer. And so the plaintiff states that she presented evidence through, is it WeChat, that Ms. G, yes, was the employer.
Yes, Your Honor. And Ms. G, in the record, submitted an affidavit in opposition where she...
Well, she says she's the bookkeeper, she was helping, I think she was helping
Yes,
her
Your Honor.
aunt.
That she's not an owner and was
Right.
not responsible for setting schedules, setting wages, or anything along those lines with respect to the actual
Well, she
corporate
said she
employer.
never worked there, and she was simply helping her aunt.
Yes, well, there were, I think, two related restaurants, one owned by her aunt, which was called, it was called Foodie's Dumpling, excuse me.
Foodie's Dumpling,
And she helped her aunt there, and then there was the other one, which I believe is the one that the plaintiff appellant is claiming, Zifu Food, and then my client never worked there. She would occasionally communicate information from John to employees as she was helping out during COVID and pre-COVID, but she was never the employer. And, Your Honor, certainly on a motion for summary judgment, there is enough here that would be a question of fact as to who the employer was. But even if she were, even if the court were to find somehow that she were the employer, there was no evidence submitted on this motion other than a WeChat, which is just a communication back and forth. There's nothing indicating that she was the employer in the WeChat. And the case that, the Wing Chan case that plaintiff appellant relies upon was decided on a default motion, and this court in Rojas against Romanoff makes very clear that for issue preclusion, that an issue decided on default is not considered fully adjudicated for purposes of use in another action. But I think even
Would the
more...
WeChat conversations be admissible on the motion in any event?
I don't believe, I mean, in this case, I don't even know if there was an official translation of the WeChat in light. I don't know whether that would be, but I don't think that would get the plaintiff appellant to where she would need to go to prevail on summary judgment. And more fundamentally than all of this is the other issue, is that there was no evidence submitted on the motion for partial summary judgment as to any violation of a labor law. I mean, the underlying complaint is for a violation of labor law, but there was no proof submitted on the motion as to hours worked, wages paid, what the violation, which specific law was violated, and what the nature of the violation was. So certainly, that is why I think the court below properly found that there was not a basis of law or fact.
I thought she did allege that there was a failure to pay the minimum wage and pay her overtime, holiday, and sick leave.
I believe that was in her complaint, but not in, it was an unverified complaint, but not on the motion for summary judgment. There was only one affidavit, and it was a 5-paragraph affidavit submitted in support of the motion, and that was really all it said was, we even quoted the entirety, that the plaintiff moves the court for partial summary judgment against defendant Hong Ji. It is undisputed that plaintiff worked as a cashier, and then attaching the daily sales report and a WeChat conversation. And then next paragraph is in Wing Chan v. Shifu Food. The court finds that Hong Ji is an employer. And then 4, as such, Hong Ji should be found liable for a violation of labor law.
Motion for summary judgment, partial summary judgment for violation of the labor law as employer of Zifu Food.
Right, Your Honor, but there's no specific alleged violation of labor law that was even submitted by the plaintiff to say, I worked X hours, I got paid Y dollars instead of what I should have been paid. There were no facts presented for us to respond to on the motion below, Your Honor.
Thank you.
Thank you, Your Honor.
Your Honor, first in regards to respondents' arguments that there's no translation of the WeChat files. Well, that's in lower court record 9-safe document 58. And besides,
I think they took issue with the translation. But in your motion for summary judgment, did you state anything, for partial summary judgment, did you state anything other than violation of labor law as employer of Zifu Food?
No, Your Honor. The only contested point between me and respondent is whether Hong Ji is an employer of Shifu Food. This is partial summary judgment. This is not, we're not.
So you wanted a determination that G was your employer?
Yes, and appellant work at 2 places, Foodie Stumping and Shifu Food. And in the federal case, the EDNY case, the court has already adjudicated that Hong Ji was the employer.
But it was adjudicated on default.
Yes.
It was not adjudicated on the merits, meaning there was no determination that G was in fact the employer.
Well, Your Honor, actually it has been adjudicated with very clear and very detailed discussion of the merit. And the court not only stated that, well, Hong Ji was in actual receipt of the summons and complaint, but also combining the law, combining the plaintiff's affirmation and testimony in that case, it's almost a 5-page judgment that Hong Ji was the employer of Shifu Food, which was also the place that appellant works. And also the, as I have mentioned to this court, respondent G did not file 1 day before the return date. So whether it should be rejected, the lower court didn't give any rationale on it. So this court should also decide first whether the opposition should be considered or not. Thank you.
Thank you. Thank you both. People v. Lamar, Whitthall.
Good afternoon, Your Honor. Dennis Fan appearing on behalf of Lamar Whitthall. When Lamar had his brain tumor removed right before his 18th birthday, it gave him a chance to live in the community for 18 months, graduating from high school, playing soccer with friends, having a girlfriend, working at a women's clothing boutique, living with his grandma who still wants him home. A young man who has functioned in the real world like that does not deserve track 1 placement with society's most dangerous individuals for potentially a decade or more.
Were there any incidents of violence recorded during that time?
There were no incidents of violence in the community. What happened during that period, and to be very clear, was he had multiple hospitalizations because his grandma was concerned when he became agitated. That's a very natural response to have when somebody has been stabbed in your home, is that you worry that something might be amiss. But this case is always...
Killed. He actually killed the cousin.
He killed his cousin, right? He stabbed and his cousin died.
Right.
And he's always been incredibly remorseful about that.
No, understandable. I understand that from the record. But his grandmother did have other issues with him in terms of his use of cannabis and how his use of the cannabis would affect his behavior. And I think the doctors also, in their reports, also made reference to this and made reference to cannabis-induced psychosis.
Yeah, that's right, Your Honor. A few of the doctors did. There's only a single doctor who has diagnosed him with any sort of substance-induced issue, and that's Dr.
Well, his
Sterling on the
grandmother
record.
believed to be the case as well, right?
His grandma was concerned that he was agitated at home, but this case from the get-go has always been about how his psyche would settle once his brain tumor was removed, not about whether at the very beginning when his brain tumor was removed, what they thought, whether it might have been that he had some substance abuse issue, whether it was that he had what Dr. Skimming
But
said,
I think one of the issues was that even after, thankfully, the brain tumor was removed, he was still exhibiting certain tendencies.
Yeah, and
certain behavioral
maybe just to even more directly respond to that, there is no court, not this court, not the Court of Appeals, that has ever held that a substance-related issue is enough to get you into track 1 placement or even track 2 placement.
Well, I think
and that's for a reason.
Yeah, but I think the issue is whether or not the brain tumor was the sole factor in his killing his cousin and also in his behavior. And the reports by the doctors seem to suggest that it wasn't only the brain tumor, but there were that he had other mental issues, psychological issues, which contributed to his behavior.
So I want to address these in turn, because the 3 most recent doctors, right? Dr. Goldsmith, his treating psychiatrist, Dr. Wittenberg, and Dr. Cawley all settled on him having just a trauma disorder, not thinking that he has even any sort of substance-related issue. But on the question of whether you're concerned that he has a substance-related issue, having a substance-related issue is not enough to get you into involuntary psychiatric commitment. Now, you can deal with substances out in the real world on an outpatient basis through therapy. Lamar has demonstrated that he's willing to go to therapy. Lamar has demonstrated he's able to function out in the real world. Lamar has demonstrated that he's grappled with the fact he talked to Dr. Goldsmith and Dr. Cawley about how he didn't want to use substances anymore, that wasn't really doing anything for him. Now, what we need is for a chance to have Lamar actually mature, actually experience what the world looks like, and to be able to grow from that. Being in a track 1 facility with incredibly dangerous individuals is not where you learn
Well, see,
about.
that's another issue. You know, the cases state that the distinction between a track 1 and track 2 is, I don't even know what it is because it's so minimal, I guess.
Yeah.
Right? But my question is, how do we find that the court, after conducting this hearing, this extensive hearing, all the evidence that was submitted, that this court was somehow incorrect in adjudicating a track 1 as opposed to a track 2? How do we do that? Based upon what? And then the other thing is, how do we have the authority to say, oh, it should be a track 2 and not a track 1 or track 3?
You know, just to address both things in turn, the difference between track 2 and track 1, of course, are a level of dangerousness, and often what you look for are things like medication compliance, whether they've gone
Well,
to
that was
therapy.
the other thing, medication compliance, because apparently he also did not acknowledge that he was in need of any type of medication. So there was that, because again, as I mentioned before, he thought that the brain tumor was the sole factor. So there was medication compliance. Track 1 is a danger to others, right? And apparently he has not exhibited any danger to others other than when he was in the facility, although there were, I think, a number of attempted suicides since the tumor was removed.
Yeah, there were no attempted suicides after the tumor was moved. The last time he was placed on medication was when he started off at Crossroads. The record is that he
I'd like to
voluntarily...
address the 26 incidents, because it seems as if there was an escalation of violence, which Dr. Wittenberg didn't even address, and certainly we know that Dr. Cawley wasn't even aware of this, but it seems that the level of violence was escalating. So can you address that? Because apparently, you know, he was transferred from Crossroads to Horizon. Seems that because of the escalation of violence, which Dr. Wittenberg was, let's just say, a little evasive in giving in his reasoning for that. So can you address that?
Dr. Wittenberg is the only expert, the only person who has testified about the incidents. And I just want to make that very clear, because if without his testimony on this, there's just nothing in the record about how to interpret these incidents. Around half of these incidents occurred at Horizon. That was about in a 1.5 month stretch. And what happened at Horizon was he was often locked in a room for 18 hours. He was often allowed to sleep for only 6 hours at a time. And what happened there is he, very understandably,
assaulted staff
reacted
members,
to,
other residents. He destroyed property.
he dealt with exogenous factors, right? He dealt with, kicking DVD players in rooms, smashing telephone sets, kicking, the water cooler. Those are things that are responses to external stimuli. What Track 1 is meant for are individuals who have uncontrollable internal stimuli. So when you look at all the 330/20 cases, you have individuals who think that their neighbor is performing voodoo on them. You have people who are hearing auditory or visual hallucinations, and they believe that they need to act out in response to those hallucinations. That is not what you have here. You have 2 years of no psychotic symptoms. You have 1.5 years off of antipsychotic medication. And going back to Judge Weber's question, at the very beginning, when he was in the community, he did have those hospitalizations. The latter 2 hospitalizations, the 3 hospitalizations, the latter 2 didn't think he was psychotic. They let him go because he thought maybe this kid has behavioral issues, maybe he needs to grow up a bit, but I don't think he's psychotic. Gracie Square.
That's my question. How do we make a determination that the hearing court was incorrect in its assessment, and we state, it should be Track 2 or it should be Track 3?
So the easiest way to do this is to take the hearing court's credibility determinations at face value. Dr. Goldsmith is who the hearing court thought was the most telling, who the hearing court gave much weight to. Dr. Goldsmith thought that this individual had a trauma disorder. You can't both, on the one hand, think that somebody is given the most weight, and then on the other hand, disagree with the exact diagnoses that individual gives you. So all you have to do is to say, look, we need to reach a fair interpretation of the evidence on this record, which is what we're meant to do. We're going to look at who the hearing court decided to give weight to. If it decided to give weight to Dr. Goldsmith, then what this court has to do is to say, based on a trauma disorder alone, I am going to put an individual in Track 1 placement with society's most dangerous individuals. That is by no means what any case has ever done. And that's not what Lamar deserves here. He needs, of course, an opportunity to grapple with issues around substance. He needs an opportunity to grow up in terms of his behavior, but being in involuntary psychiatric confinement is the last place on earth that you would want to grow up in.
How different would it be for him in Track 2?
So Track 2, the focus, and I get this a lot because the difference between Track 1 and Track 2 can be elusive. Track 2, the focus of treatment and the focus of therapy is to often put you on a path to being back in the community. This is a young man with his entire life before him. He's still only 23 years old.
Tracks, he's still in a facility.
He's in Track 1 now. There was a temporary.
No, I'm saying Track 2. He's still in a facility.
He's in a facility. They're called non-secure facilities,
yes.
But it's full lockdown. You need an order to get out. You need to get an order to get released, to get furloughed. But the focus of therapy there is for him to reintegrate with society, to find a way to say, okay, maybe if you need some substance issues, maybe if you need to understand better your substances, we can do that. If you need monitoring, we can do that.
So that I can understand you better. Track 1, he would be in a secure facility, and he would be what? In a separate room by himself? Would he be with other patients?
Yeah, I think the difference is the focus in therapy, less so than like the exact parameters. Because in Track 2, it's not like you're just free floating. You have a room that you're able to come in and out of at all times, right? It's still an incredibly secure setting.
Track 1 and Track 2, are they both secure facilities? And just Track 2, it's more the thought is more in terms of therapy and reintegration.
That is, I think those are fundamentally the differences, right? Where Track 1,
the focus of Track 2 is to reintegrate. What's the focus of Track 1?
The track one should be to reintegrate, but I think in reality, if you look at things, and if you look at anyone who's entered into Kirby, the reality is you're there for a decade or more, right? So the focus there is this thing, you're an incredibly dangerous individual. If we don't have you put on antipsychotic medication, if we don't have you under total lock and key, things could go really, really wrong. This is an individual who, before the civil commitment order came out here, hadn't been on antipsychotic medication for a year and a half. That's how much he had progressed since the time of having his brain tumor removed. Now, that is a strong indication. That's an indication both in George L. and David B. when you look at track one or even track two, is the need for medication. And so when you look at like whether he's willing to be on medication, when he started at Crossroads, they said, we don't know if you have schizophrenia or not. We want you to try out medication. He voluntarily complied with that. He said, sure. He never missed a single dose of that, even if he believed that this was all caused by the brain tumor. Even though he was like, this might be all caused by the brain tumor, I'm still willing to try this out.
I understand. What you're asking us to do is to find that the court erred in finding that the defendant has a dangerous mental disorder, supporting civil commitment, and in the alternative, track two.
Yeah, I think that's entirely correct. We think this individual should be out in the community. We think the community has many supports for him, which include any sort of outpatient care, the supports that you have with your family. Plenty of individuals are out in the community with mental disorders.
That's the question. When you say should be out in the community, if we stated that it would be track two, does that mean that he's automatically now released into the community, or does it just simply mean that he's in a facility which is going to try to reintegrate him?
He will never
prepare him for reintegration.
If he's in track two, he will never be in the community without a court order. That's full stop, period. There will be another judge who sits on it, looks at the record, says, Lamar, have you grown up since, the last time we talked? Have you gone to therapy?
Something else that was in the record, I believe it was in the record, that the tumor has reappeared?
Yeah, we dropped a footnote. The tumor reappeared. We weren't able to find out about it until pretty late. It got removed again, so he had a successful surgery during the interim stay that was part of this case on appeal. He was actually able to get medical care. But I want to just mention one part about that, which is that only goes to show why putting him in a less restrictive setting, one that he can go out, get medical care, is incredibly critical. Because, what Lamar needs is yearly neurological screenings. What he needs is an ability to monitor the primary thing that is affecting his psyche.
And in terms of the monitoring, he can still apply every 6 months, right?
Hypothetically,
For
Your Honor, hypothetically, I think if you look at your case law, there hasn't been an individual who's ever gotten out in 6 months. There hasn't been an individual who's ever gotten out in a year and 2 years. And I think that's for a reason. Is once you're in track one, the presumptions around whether you should be out completely sort of flip against you.
Thank you.
Good afternoon. If it please the court, Kate Trefon for the respondent.
So how do you respond to the adversary's position that the court afforded great weight to Dr. Goldsmith, yet didn't follow Dr. Goldsmith's, I don't want to say advice, but conclusion that it's a trauma disorder?
Sure. So the court did give great weight to Dr. Goldsmith, and also two things can be true at once. Dr. Goldsmith did find a trauma/stressor related disorder, but Dr. Goldsmith also said that the defendant had a dangerous mental disorder, therefore requiring a track one commitment. So the court did give that great credence. And of course, that was also buttressed by the other two people's experts that were called Dr. Skimming and Dr. Sterling, who also said, yes, he has a dangerous mental disorder requiring a secure commitment in a secure facility. This is compounded, of course, which my friend has not addressed at all, Lamar's total lack of insight into his mental illness. And as one of the experts, and I believe the court held, perhaps that is somewhat explainable by the fact that Lamar's defense team has been consistently telling him it's just the tumor, and he is a young man, and that is incredibly sympathetic.
Well, he stated that the sole factor was the tumor. He to some extent downplayed the use of cannabis, although he stated that he had been using it, I think he said, since he was 15 years of age, or something of that nature. And he also stated that he did not believe, but because he believed that the tumor was the sole factor in his behavior, he didn't believe that medication was needed or necessary, and so that led, I guess, Dr. Goldsmith to conclude that he would not be compliant with medication in the future.
Correct, absolutely. So that is the main point of concern here, is that Lamar has no insight or appreciation into his mental illness, which he has been diagnosed, and I can get into the rule-out / provisional diagnoses, which by definition are part of a diagnosis.
So does that translate then to his being a danger to others?
Yes, because he has shown a refusal and a failure to discontinue cannabis use.
For counsel, but when he was out in the community, there were no instances of violence, were there?
There were, Your Honor. There's
In the
document in the community when he was with his grandmother in the time between the murder and the hospitalizations. He threatened to push a nurse and aide down a flight of stairs, and there was also documentation that the family had to barricade itself inside a room because they were, for lack of a better term, afraid of him. So that's the threat of violence in the community that again has been glossed over, but was considered by this court. And to my point, and to Justice Weber's point, there is nothing in the record that shows this was an abuse of the lower court's discretion in coming to this assessment and in adjudicating Lamar a track 1 acquittee.
Well, that's why my question is, how would we determine that the hearing court was incorrect? It would have to be credibility, or it would have to be an abuse of discretion.
And it's not here. It's simply not here. This was an extensive record. I mean, Your Honors have before you the record, thousands of pages, testimony, medical records, historical medical records, videotaped interviews with Lamar.
But we also have the power, if we choose to exercise it, to substitute our discretion for that of the trial court.
You
right,
do.
even in the absence of an abuse. And so what, in your view, makes the disposition of this case a track 1 disposition as opposed to track 2?
So I'm not equipped to give a medical opinion as to this. However, based on the evidence that was presented, the concern is that Lamar is a danger to himself and others. That has been supported by the evidence. My opponent's view that Lamar has some growing up to do is somewhat flippant in the sense of what has occurred. And the track 2, also let me just say that track 2, the option of track 2, the argument for track 2, was never raised at the hearing below. The defense team was always looking for a track 3. Yes, excuse me, I conflate the tracks all the time. And so the people didn't really have an opportunity to respond to that. But to the extent that I have the opportunity now, the statute has built in an anecdotal evidence offered by my friend here aside, the statute has these evaluations and these constant reassessments built in. In fact, Lamar has had one recently. Every 6 months, they are up for review, and based on their treating team and the facility, there are opportunities that they will be deemed a lesser track and adjudicated a lesser track.
So your friend stated that that's never been done or rarely done within a 6-month or 1 year or even a 2-year period.
I don't think he can speak to that. I think saying that's never been done is an impossibility. But I can't either, nor can I speak to that. I'm not.
But isn't it easier for someone to be released into the community from a track 2 than from a track 1?
Well, I think you have to, I mean, again, if we're talking anecdotally, I think if you're going from a maximum secure facility to being released in the community, there are other steps in place. So I suppose short answer, yes. But again, there are statutory bumpers and protections in place that he needs to be receiving this treatment. He has been non-compliant with medication. He's been resistant to therapy. He's tested positive for marijuana every
Did his
single
treating
hospitalization.
doctor say that he was non-compliant with medication, or that he just simply didn't need it anymore?
Well, both. He was non-compliant and then was forced to
Wasn't he tapered down or tapered off Abilify?
Yes, during his time at Crossroads, and then as Justice Mendez pointed out, his episodes of violence escalated almost in step with the tapering off of the antipsychotic.
I'm sorry, Counselor, just because I can't remember. How old is the defendant?
I'm sorry, say that
How
again?
old is the defendant?
Currently, I believe he's 22, 23.
I think he's 23.
Yeah.
I did the math right. Thank you.
Thank you.
Your Honors, I just have a few points. First of all, this isn't an abuse of discretion standard. This is a fair interpretation of the evidence standard. We're not asking the court to look over any credibility findings. All we're asking the court to do is take every expert's testimony at face value. The entire point of this case has always been to see how Lamar settles, how he progresses, and everyone in the past 2 years who has looked at him thinks that he has a trauma disorder.
What is the legal standard for a Track 2 designation?
The Track 2 designation is you still have an element of dangerousness. The Court of Appeals made that clear in David B. It's just a lessened, lessened element of dangerousness. I think courts have not been super
That doesn't
clear.
seem too clear.
I don't think courts have, the clearest I can say it is David B. had a number of factors, including whether you've gone to therapy, whether you have insight, whether you have medication. I think on those things, my friend on the other
insight
side.
point, your friend pointed out how several of the state's experts indicated that he lacked insight. And it wasn't just, a partial lack, it was an abject lack of insight.
So I think insight breaks down to a number of factors, and I kind of want to, because insight is a funky label once you kind of think about it. One is medication. He was voluntarily on medication. They never had to forcibly medicate him at Crossroads or Horizon, right? Two is whether you're going to therapy. Kate Payne, his therapist, said he's beloved by the therapist there. He's beloved by the staff. When he gets stressed out, it's not just he has, goes to therapy at his appointed times, but when he is stressed, he goes and seeks out more therapy. That's an element of insight. The last is if you feel remorse about what you did, right? If you can mentally distinguish right and wrong, that's an element of insight as well. And he has always, from the get-go, as soon as he understood what was happening, he has always felt terrible. I mean, Lloyd Hill was like a brother to Lamar, and so he's felt terrible about what happened.
So the lack of insight here stems from his position that his conduct is directly attributable to the tumor.
Yeah, and I don't think that's a lack of insight. I mean, just to be very clear, the last 3 doctors who looked at him, including the DA's doctor, our doctor, his treating psychiatrist, all said he had a trauma disorder and that this stemmed from a brain tumor. So if you are a 22-year-old and you're listening to 3 psychiatrists,
Yes, but we
that's
still
not a
have
lack of insight.
incidents that occurred after the removal of the tumor.
That's right, and none of those incidents, and I think this goes to the causal point, which Supreme Court never addressed, none of those incidents was there a write-up that said, at this time, he engaged in this incident, he had some hallucination, or he had some auditory hallucination that was telling him to
So
beat up some kid.
is it correct that you did not explore a Track 2 with the hearing court?
I don't think that's correct. I mean, we can look at the record below, but we advocated for as far as we could go on this, which is Track 3. It's ultimately up to the discretion of the
The
court.
reason I asked is because I didn't know whether there was anything that was fleshed out with the doctors in terms of, okay, would a Track 2 also work or be beneficial in this case?
Yeah, I mean, all the factors are the same, right? It's whether you have a mental illness and whether you're dangerous, and this is left to the discretion of the hearing court. Dr. Colley addressed this in his testimony, so if there's at some point, Dr. Colley was the one who kind of addressed this, because Dr. Colley thought that Track 1 was completely off of the table in terms of addressing Track 2.
Thank you both. And Ms. Rush and Ms. Montoya, thank you as well. Best Work Holdings v. Ma.
Good afternoon, Your Honors.
So my notes were incorrect. You were late.
Yes, Your Honor. I
Yes.
apologize for that.
Yeah, I had the notes incorrect.
Okay. Good afternoon.
So you will be given 3 minutes as well.
Sure. Thank you, Your Honor. So this is, Your Honor, this is a straightforward case. We believe the trial court, the Supreme Court, early and prematurely denied a grant the motion to dismiss. So first, the principle in ruling on the motion to dismiss is the non-movement party, the responding party shall take all the benefits from the pleading papers. And apparently our client has not enjoyed such benefit. And also there are 3 issues on this case. The trial court judge didn't grant the motion to dismiss based on the documentary evidence. However, we don't believe they are documentary evidence. They are the affidavits, the resumes, the emails, and the visa applications. The resumes and the emails are self-reported documents, and they are hearsays. They have not been verified. As to the affidavits, there are clearly rules on the affidavits can be controverted. And as to the visa applications, that was filed by my client's employer, so it's not executed and verified by my clients. And as to the second issue is about whether the job, the FLSA and the NYLL, the exemptions shall rely on the papers, but not based on the actual duties. It is our belief they shall rely on actual duties and not based on the hearsay, the contested papers. The last issue about the case is we believe my client has the right to be informed of her rights. So this is what we call the informational injury. So the law gives my client the right to be informed of her wages and the notice when she was fired. And without this notice, the law provides the right and my client suffered injuries. So therefore, we respectfully ask the court to reverse the trial court order on our motion to dismiss and remand this case to the discovery stage. Thank you, Your Honor.
Thank you.
May it please the court. Robert Liu from Balance Law Firm, appearing on behalf of respondent Best Work Holding New York LLC. Your Honor, we respondent generally stand on the brief we submitted. So here I will just briefly respond to the points made by the appellant. His first point is the non-movement should enjoy the benefit of doubt, but the law is very clear. Such favorable treatment is not limitless. Bare legal conclusions and just merely alleging the elements of a claim in general fashion without more does not satisfy the liberal pleading of standard of CPLR 3211. The second point, appellant said that they don't believe the documentary evidence appellant Best Work submitted. However, we should note that appellant during the motion practice, she never submitted any affidavit to say the contrary, and she stood on the counterclaim she filed, and she never tried to amend the counterclaim after my client filed the motion to dismiss. So there was ample opportunity for her to amend or to submit affidavit, but she didn't do so, and now she claims that she didn't believe the documentary evidence we submitted. We contend that that's insufficient. And also with respect to the affidavit my client submitted, the law is also quite clear. In fact, this court, the first department has held in this case, we cited in on page 16 of our brief, it's in footnote 5, in Mulaha versus Goldman, that this court held that an affidavit is an appropriate vehicle for authenticating and submitting relevant documentary evidence and may provide connecting links between the documentary evidence and the challenge statements. So there's nothing inappropriate for the lower court to rely on that affidavit. And then the last point the appellant made was regarding the so-called informational injury. That's outdated law. I mean, a long time ago, the law did say that, but that changed since the US Supreme Court held to the contrary in TransUnion, and also the Second Circuit, the federal court, the Second Circuit Court held in Guthrie that there has to be concrete downstream harm. So just merely informational injury is insufficient. Here, Ma said nothing about the concrete downstream harm. So she lacked the standing.
Thank you. Thank you both. Last case for argument, People v. Vadim Schulman.
Good afternoon. May it please the court. Matthew Bova for Mr. Schulman. It is unconstitutional under the Second Amendment to impose a drastically higher sentencing range for in-home possession based exclusively on prior misdemeanor convictions. The sentencing scheme that was applied to Mr. Schulman is therefore unconstitutional under Bruin. This case presents the question left open by the Court of Appeals in 2013 in People v. Hughes, because there the issue was, well, you're not challenging the conviction, but challenging the sentencing scheme. Does the Second Amendment cover that? And that question has now been answered by Heller, by Bruin, and by Rahimi.
So is this foreclosed to any extent by the fact that there was a valid waiver of the defendant's right to appeal?
No, because, well, first of all, on its face, the written waiver excludes challenges to the legality of the sentence. But in any event, under Callahan and under the Court of Appeals' long-standing precedent, you cannot waive a challenge with an appeal waiver to the legality of the sentence. And that's what's critical here, too, as to preservation.
I'm sorry. Under Thomas, the valid waiver of the right to appeal forecloses a challenge to the Second Amendment, a Second Amendment challenge, as well as to sentencing?
No, the appeal waiver cannot cover a challenge to the legality and constitutionality of a sentence. This court has held that an appeal waiver in Omar Johnson. This court has held that an appeal waiver can bar a challenge to the conviction, to the indictment. But this is a challenge to the legality of the sentence. We are not arguing that the state lacked the authority to punish Mr. Schulman for possession of an unlicensed firearm. The point here is that his sentencing range would have been as low as a conditional discharge and as high as 4 years, because this was in-home possession, but for the prior misdemeanor. The prior misdemeanor bump up elevated the sentence drastically. It went to a 3.5-year minimum to a 15-year maximum. There is no historical tradition for that kind of drastic shift in the sentencing exposure exclusively because of prior misdemeanor convictions.
Well, as to the historical tradition, I guess we're taking for Bruin now. Was this Second Amendment issue preserved?
No, it doesn't have to be, because it goes to the legality of the sentence.
But if it's not preserved, then how do we have an adequate record to gauge the historical background of this type of regulation?
Well, because that's not the kind of record development that the unlawful sentence exception is getting at. The unlawful sentence exception under Nieves, under Sams, has been long established that where the record indicates that there is no factual debates that bear on the legality of the sentence, such as historical facts, dates, etc., then those claims can be raised for the first time on appeal. The only factual dispute, well, to be clear, the government doesn't raise any factual disputes in the way that the unlawful sentence exception understands it. The only dispute would be, what does the history show? That's not the kind of factual dispute that we're talking about when we get at the unlawful sentence exception. That's a legal debate. Every day, courts will consider legal history for the first time on appeal, and the unlawful sentence exception has never faded away because there may be debates about history. But in any event, the 440 record and the 440 litigation, also the litigation before this court, shows there is no dispute. The government has never even tried to establish that there is any debate about the history here. The government has presented no historical evidence, no statutory evidence whatsoever indicating that this kind of drastic sentencing exposure is authorized by the history.
You're challenging the bump-up statute.
Yes.
Is that correct? So you're stating that the bump-up statute is unconstitutional.
The sentencing exposure, well, to be clear, we're challenging the sentencing exposure.
So you're not challenging the bump-up statute, you're just challenging the sentencing under the statute as unconstitutional. But my point is, would the Attorney General have any input in this in terms of the constitutionality of that section?
Well, this is really as applied because it's based on the fact that it's in his home, and that's what the record shows. So it's not a
But that's what the statute states, right?
Right, but that's based on the factual issue in this case. It wouldn't be in every case where we have this problem. It's only where...
My point is, if you're attacking the constitutionality or you're calling into question the constitutionality, even of a portion of the statute, would the Attorney General not have to have some input as to your argument.
Well, that procedural defense has not been raised by the government at all, so therefore it's waived. And in any event, the executive law, section 71, says that the remedy for that is to allow for the Attorney General to have input.
And you're stating that, again, that Thomas, in the cases dealing with the valid waiver of right to appeal, that they do not cover and do not speak to whether or not the issue as to the constitutionality of the sentence survives the waiver.
Yes, because it's an unlawful sentence. Well, those cases don't address the people. I think if Your Honor's referring to People versus Thomas from the Court of Appeals.
Yes.
Yeah, that didn't address an unlawful sentence.
We have a decision, I think it's Camera, if I'm not mistaken. I thought we had kind of addressed that issue in Camera.
I think, in People versus Francis, which is a case that the government cites, this court considered an unlawful sentence argument in the context of a different sentencing scheme under the Second Amendment. And this court did indicate that that was the kind of thing that, because it was challenging the constitutionality of a statute, it did have to be preserved.
Right.
However, that decision should be reconsidered for really two reasons. It's flatly inconsistent with Sams and Morse. Sams very clearly held that the unlawful sentence exception applies where the face of the record shows there's no factual disputes, and it's cited to Morse, which was an ex post facto case, a constitutional challenge. Footnote 2 in Morse explicitly says this is a constitutional challenge raising an ex post facto claim. It's clear on the face of the record, therefore it's covered by the unlawful sentence exception.
And then my colleague had mentioned preservation. I think we also have a case, Cabrera, I think, People v. Cabrera, that this court decided where we spoke to the fact that preservation was necessary.
Well, Cabrera, in the Court of Appeals, there was one sentence that the Eighth Amendment challenged had to be preserved, but that's not our argument. Our argument here is not about a fact-specific Eighth Amendment challenge, the kind of classic cruel and unusual punishment argument that requires factual development, that requires you to balance all those classic factors.
So Cabrera would not, the Court of Appeals case, Cabrera would not have any guidance. We would not be guided by that where we're talking about the Second Amendment.
No, because we agree that typically Eighth Amendment challenges do have to be preserved because that requires classic factual development.
Is there anything in that case which specifically states that it's only as to the Eighth Amendment and that it would not hold true for the Second Amendment as well?
Well, the line in Cabrera is that the Eighth Amendment claim has to be preserved. It doesn't address...
Well, it talks about constitutional claims, but thank you. You have time on rebuttal.
Thank you.
Good afternoon, Emily Aldrich for the People.
So do you agree with your friend that People v. Thomas, as well as, People v. Thomas does not foreclose a review of these issues?
Absolutely not. In fact, I believe that Francis is very authoritative here. In fact, the majority of your honors were on the panel that decided that case. And that one, this court held that that despite styling the claim as a challenge to the legality of the sentence, he's actually raising a claim about the constitutionality of the statute. That is exactly what is happening here, and my friend does not dispute
The real challenge here is as to the bump up, right?
I'm sorry?
The real challenge here is as to the bump up.
Yes. And here, there's all sorts of things that could have happened had this case been preserved, a record that could have been developed. For example, the people could have presented evidence demonstrating that he is not a law-abiding citizen. The Second Amendment applies to Second Amendment protection goes to law-abiding citizen. Nothing in Bruin suggests that a person may disregard licensing laws and then successfully invoke the Second Amendment to attack the severity of the resulting punishment. Additionally, the prosecutor could have argued that keeping guns away from people who've shown that they cannot be trusted to obey the law is consistent with our nation's historical tradition. As we say in the brief, the Supreme Court has said that recidivism is the traditional, if not the most traditional basis for sentencing courts increasing an offender's sentence. And this happens, as the 440 Court pointed out, far beyond the context of Second Amendment claims. Finally, to not require preservation here encourages gamesmanship. He had an arsenal of weapons. He had 8 firearms, including 2 assault rifles, 5 large capacity magazines, more than 1,200 rounds of ammunition. He chose to resolve 53 charges against him with a plea to a single count of violating Penal Law 26503 sub 3. And this was a post-Bruin claim. He's not alleging ineffective assistance. Had he raised this claim below, the prosecutor could have made any of the arguments I just mentioned. Also, there were multiple other counts of the CPW, the criminal possession of a weapon in second degree, that didn't involve any sort of bump up, whether it's for the assault weapons and for more than 5 guns. So had he raised this claim below, it essentially would make it so we would not even have to be addressing these arguments at all in the first place. And if there are no further questions, we rest on our brief. Thank you.
Thank you.
It's almost always true in a case involving a plea to an unlawful sentence that the government could have swapped in a lawful sentence count. That's how if that were true, if that theory worked, the unlawful sentence exception would never apply, because in every case where a defendant pleads to one of several counts and that count has an unlawful sentence, the government could defeat the application of the unlawful sentence exception by saying, oh, had this been raised below, we would have swapped in another charge. That's not the law. The law is that when there's an unlawful sentence, it can be raised on appeal where it's discernible from the face of the record, and the remedy is to fix the legality of the error.
Well, but the preservation argument is well taken, because again, if that argument had been made below, then perhaps the people would have been able to flesh out the record a little bit more and state that the reason for it was the bump up in the sentence was because of the amount of the large number of weapons in the defendant's home.
No, but that doesn't get to the unlawfulness of the sentencing range. The problem, those arguments about they could have introduced evidence as to his entitlement to possess the firearms, background, etc., those arguments perhaps go to whether or not he has a constitutional right to possess the firearm. But here we're talking about the constitutionality of the sentencing scheme. His background.
Maybe your friend's point, if I understood it with respect to preservation, a situation like this, where it's multi-count, if you raise it and you're successful before the nisi prius, they then could strategically decide to pursue a different charge or charges that wouldn't have implicated this concern.
Fair enough, Your Honor, but that's always true in the unlawful sentence.
No, it's not always true. I mean, again, as you stated, you started in your argument, everything is fact specific. So it isn't always true.
Well, the only facts that matter here, as far as the sentencing claim, I agree. There are many facts that may bear on a challenge to the indictment or to the constitutionally protected nature of the conduct. But the only facts that matter as to the sentencing scheme are all uncontested. It's in his home, he has prior misdemeanors, and there's a penal law that imposes a drastic sentencing range distinction. That's all that matters for the purpose of the sentence challenge. That's the distinct challenge that we're raising here.
Thank you. Thank you both.
Thank you.